So what do we need to know about powers of attorneys?
Well,
Powers of attorney, sorry.
I think it's kind of hard to say. I think it's an important point to bring up because every so often you'll have a closing where somebody will say, kind of at the last minute, hey, we need a power of attorney, and you have to kind of plan ahead a little bit on something like this, and it's different from the perspective of a buyer versus a seller. On a buyer, usually, if it's a cash transaction, there's a question of even is it necessary? On a finance transaction, yeah, it's a little bit more necessary. If you have two parties that are signing on a mortgage, or if you just have one person that's a borrower, and that borrower can't be at the closing, there's always the other option where we could do a mail away. But if a mail away is not an option at all,
takes a lot of time.
It can. That's right. It can take time. You have to wait for the package to come back. You have to make sure it's properly executed. You can appoint somebody locally to that's going to be in your the market where the property is located to serve as the attorney in fact. And when you do that, though, it's not just it's not really your election. It's really the lender has to agree to allow for this to happen. They got to approve the power of attorney, the form, and what it says. It can't be like a unlimited, because powers of attorney for real estate purposes are typically very specific, specific to the property, specific to the function that's being carried out by the power of attorney.
What is the adequate time? Like, what kind of time frame does somebody need to get a power of attorney done if they're getting a mortgage and if they're the buyer?
That's a good question. So, we had one not too long ago where we were told at the closing that we needed a power of attorney for the buyer.
You're not a magician.
Yeah, so we did get that done. It all had to do with the flexibility of the lender, but we did get it done. But that's not ideal at all. Like you said, it takes a little bit of time. You don't want to bounce these things immediately off a person. No. So whoever it is in the chain of command. So the lender will usually approve something like that. Takes a few days, and then it has to get circulated for execution, and then get back. You got to record that document in the public records if you're going to rely on it to execute a loan package. Right? The underwriter is always going to say, look, they may not be available to sign, but is there a question of the mental capacity? Do they have the capacity to be able to execute the document? If they have the capacity and they have an availability, then they would always defer to have the deed signed in original and then a power of attorney to be done because of maybe an inconvenience to get to a closing. So there's the connection. The underwriters will always want to push back in that way. Always. And also it's important to note that title could be held in a company name. Title could be held in an LLC, for example. Title could be held in a trust. You can't give powers of attorney in those situations. What you do is you give it by resolution, or the trustee is appointed to serve, or a successor trustee would be appointed to serve. You don't usually give powers of attorney in those situations.
So somebody outside of the trust cannot sign as power of attorney.
It's not typically done that way.